following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the law surrounding Parate executions in Sri Lanka. What's the current context surrounding this area of law, and is its application in the best interests of the country? A very good evening and thank you for joining us tonight on Law, Land and Liberty, where we bring to you key legal topics and break it down for the layman. Now, after quite some time, we're back with a topic that was hot news a few weeks ago, and that's on Parate law. What exactly is Parate law, and what exactly is the concept behind it, and why is it causing so much stir up in the current context? Well, to speak about this very convoluted topic and to break it down concisely for us, we have with us someone that is best suited for the job, I believe, and that is Mr. Priyantha, Alagiyawanna, attorney at law. So thank you very much for taking the time to join us and educate our viewers on this topic. Well, before we get into the specifics, is a little bit of an introduction on Mr. Alagiyawanna. He is a senior lawyer with over 21 years in practice, specifically in this area as well, with a master's. So best to say that he is well suited for this topic. Well, before we break into the topic, here's a little bit of a breakdown on what we're going to be discussing today. First, we'll be breaching on the basics and the fundamentals. What is Parate law and its fundamentals? Next, we'll be going into the current context and what we've seen as recent developments, and finally we'll be talking about the future of Parate law in Sri Lanka.
Hello, my name is Neddi Piris. I am a student who selected the University of California last A-level examination. My question on the fundamentals: what legislature governs parade executions?
All right, well, without any further ado, let's get right into the discussion. So once again, thank you very much. We have a lot to unpack when it comes to this topic, especially when we came to recent developments as well. But before we get into the current context, I believe it's important to give the viewers a little bit of a fundamental understanding on what Parate law really is. So if you could start us off, sir, by explaining what exactly this Parate law really entails and how is it set in the legal framework of Sri Lanka?
Yeah, good evening first. And thank you for inviting for this important topic, I suppose. And Parate execution process now, with the intervention of the legislature, has ingrained into our legal system. That's by an act of parliament and several other acts of parliament which was enacted prior to 1990 as well. So if I say about the Parate execution definition for the understanding of the layman's viewpoint, Parate execution is a process whereby the creditor, without assistance of the court, seek to sell the property by adopting a resolution. Now, Parate execution has been permitted to the commercial bank and licensed specialized bank by Act number 4 of 1990. However, prior to that also, the government-owned bank such as Bank of Ceylon and some other banks, NSB, those banks also were vested with the Parate execution power. However, as we go on in this topic, I will explain to you slowly and slowly this has been now ingrained into our legal system. Initially, through the several acts introduced in formation of the government-owned entities and the banks, and then into the private sector.
Right. Just a question of curiosity, sir. Does Parate law and Parate execution still count as a non-court procedure?
Yes, exactly. Save and except at the stage of execution, that is to obtain a delivery of possession, the banks are empowered to seek the assistance of the court in a summary procedure. However, up to that point, from the very inception, that is adoption of the resolution, communicating, conducting the auction, all are under the guidance and the purview of the board of directors of the banks. So once that process is completed, in order to obtain the assistance of the court, the provisions are made under Section 16 of the Act number 4 of 1990 to make an application to the court for delivery of possession. So you will see the process of selling the property and conducting the auction for the matter for the bank and their appointed auctioneers. Thereafter, since most of the properties are occupied by the borrowers, you have to make an application to the court. Normally we make bankers are making application to the District Court of Colombo as per the law to obtain the delivery of possession. At that stage, the assistance is sold by the bank. As we go on to more detail, the intervention of the court, of course, is sought by the borrowers who obtain the facility. At the stage, a resolution is adopted and the more importantly, at the time auction is conducted.
Exactly. So through this discussion, we can understand that Parate execution is not completely devoid of legal intervention, but it is intrinsically connected now with the passage of time. We've seen it increasingly being affiliated with the law in itself. I think now that we've gotten a good basic understanding on what Parate law really is, the definition, what exactly it means when we say Parate execution, it's important for us to delve a little bit into the historical context within which Parate executions even came to be in the country. If you could explain to us, sir.
So in our legal system, in order to obtain a judgment and decree in respect of any property or otherwise, you have to resort to the court of law. That's a basic principle. So quite apart from that, this legal concept has its roots in the Roman Dutch law, in the Roman law, Roman Dutch law. And then without assistance of the court, even in South Africa, in limited circumstances in respect of the movable property, auctions are conducted. When it comes to the England, under the Law of Property Act of 1925, the similar provisions, very much similar to the Parate executions, are there with certain safeguards which are different to our legislations. So what has happened with the passage of time, initially 1931, when the State Mortgage Bank was, the law pertaining to the State Mortgage Bank was enacted, the Parate execution power was given to them. That is way back 1931. Then thereafter, slowly Bank of Ceylon, National Saving Banks, and some of the banks were vested with the Parate execution power. So People's Bank, I would say People's Bank and the Bank of Ceylon. So however, the other private banks, with the expansion of the economy, there was a need for them also to recover their money in a very quick manner, I would say efficient manner. Because once you lend the money, you must recover so that you can thereafter re-lend the money to the other customers. So in order to facilitate this process, there have been many demands to deviate from the regular procedure. Under the regular procedure, you can file a plaint and recover the money. It takes more time. So even when Parate execution, one has to understand it is attached to a property. So there is a principal obligation and the security. In the principal obligation, basically you have borrowed the money, you agree to pay the money. In the security, you have pledged or mortgaged the property as a security from the repayment of the loan. So if the customer default before 1990, private bank, they had to file a mortgage bond actions. Mortgage bond action are governed by the Mortgage Act enacted in 1949. It has certain provisions which must be complied before the even matter is fixed for trial. So you have to go to land registry, register spenders, register the tender to the court lawyer's declaration. Certain procedural steps were there. Those were time consuming. You know our legal system somewhat fragile. It takes a lot of time to dispose a matter. If some litigant want, really, they can delay the matter intentionally. There is some room for it. So therefore, there was a call by the private sector to introduce the provisions such as Parate execution. There was a demand, and it was resisted. Well, it was resisted mainly due to the opposition from Bar Association of Sri Lanka. They oppose it. They term it as an invasion of rights of the people. It's a draconian. However, as time goes on, so with the economic issues, it's not even in the present scenario. Even then, before 1990, there were issues, economic issues. Recovery process was slow. Then there has to be some solution. Then only this Parate execution law was introduced to Sri Lanka by Act number 4 of 1990. Along with that, I must mention that 13 other enactments also enacted, especially Debt Recovery Act number 2 of 1990. It was about entire process. You see, something which is unknown to our legal system was slowly ingrained into the legal system by the intervention of the parliament. That's what exactly happened.
I see. So because of certain interventions, and also would you believe that such inclusions into the law was in order to keep up with the times and the current economic context? And if that was not the case, would we have had Parate law in the country?
So you will see the recovery of money in an expeditious manner is a great matter for concern in the money market. So you lend the money, you must be able to, in a position to recover it, so that you can again borrow those money to the, lend those money to the needy people. So then only the economy will flourish. The people need the capital to run their business and bring new businesses, etc. So that was the need by 1990. So you needed to recover your money because our process, with all due respect to the court, is little slow. But there have been many measures introduced from there. Even now, of course, there are certain delays. It's not common to Sri Lanka. It's common to most of the countries, even except some Western countries. So in order to meet that requirement only, this law was enacted. That was the intention. I must say one thing. Now, the recovery of money, because these laws are applied not when you are paying the money. So these laws are applied when you are in default. So though this is called as a draconian law, once you are in default only, the process will trigger. And so I must say that yes, there was a need. Even now in the present context, we can discuss as we go on. Of course, yes, there are conflicting claims. The borrowers always say this is a draconian law, invasive of their rights. However, in the other hand, lending institutions also have been complaining that, of course, even this process is not sufficient at time. They have complained that it is also slow, and any person who, of course, deliberately want to delay the process can delay it.
Exactly. There's room for malicious intention and also misuse of the system, as we have discussed in previous programs as well. And Parate execution is no stranger to that as well. So we can see that at some point it was meant in purely for the intention of delivering justice and ensuring that capital flows as it was intended to. I think now that we've got a little bit of a good understanding on the context and why exactly Parate law exists in the country, could we please delve a little bit deeper into the institutions that are responsible for handling Parate executions and the authorities that are involved and what role specifically they play?
Yeah, so I indicated to you previously, basically the government-owned bank were vested with the power of Parate executions. So this power in 1990 were given to mainly to the licensed commercial banks. In the money market, you will see there are various institutions at various levels. There are financial institutions, then there are banks, there are licensed banks, licensed commercial bank, licensed specialized bank. So initially when the Act number 4 of 1990 was enacted, this power were only vested with the licensed commercial banks. So by Act number 1 of 2011, that power also extended to the licensed specialized bank. Those are the two only institutions which are coming under the purview of this Act. You will see the other there are financial institution, finance company regulated by the central bank, but they have not been given the power, though there are requests by them to extend this power to them also. That is for good reason, because you see in the money market and the financial system, there are different levels. Bank play very vital and pivotal role in shaping our economy.
Exactly.
So the intention was to allow them some breathe so that they can recover their money quickly and give it back to the customers who is willing to do the business.
Breathing room, essentially.
Breathing room, yes.
Yes.
Money must be flow. I mean, the flow must be there. The money must come, because you borrow the money. You repay it within reasonable time as per the agreement, terms and conditions of the agreement. If you don't do it, you are in default. Then there must be some available measures to the banks.
Exactly.
So this is a quick and efficient method introduced. Otherwise, you have to, as I indicated earlier, you have to go to court. It will take time. Settle with appeals. It takes some years and years.
And at some point, maybe the financial liquidity would have not been worth it with the duration that was spent on the litigation as well.
Yes.
But when we talk about the advantageous aspect and the breathing room that Parate Executions provide for commercial entities and banks that need to maintain their liquidity and cash flow, how exactly does Parate Executions affect borrowers? What kind of protections have we seen on the borrowers' end in order to make sure this is not a one-sided piece of law that we're enacting in Sri Lanka?
So I must say that even in the present market context, there is a very heavy competition among the even lenders. On the one hand, there are financial institutions. On the other hand, there are banks and other institutions. Quite apart from there are some grassroots level organization, institutions, regulated and unregulated, who are engaged in the business of lending. When it comes to the banks, they always, I must say, one of the mistakes we are committing, our banks look at the security and probably not the creditworthiness of the customer. In lending, what is most important thing is to ascertain the creditworthiness of the customer. But in any event, our financial system always look for the security. The facility must be secured. So what happens? Security is taken more often than not. In such a scenario, so rights of the borrowers are concerned. Of course, their rights are always basically all the contract when it comes to the secured by the mortgage are regulated, and those contracts are in writing. Basically, it's a privity of contracts. Now, this Parate law comes into the operation if you breach your obligation under the loan contract. Then the process will trigger. So under Parate execution, you are obliged to pay, if I would say, when you obtain a loan, you are obliged to repay with interest. Loan installment, etc. are set out and agreed upon at the outset. So when you are in default, what happens? Banks serve the letter of demand. Sometimes bank are demanding the customer to show cause as to why the Parate execution process should not be conducted. Then they adopt the resolutions. So in such a scenario, you see, as long as loan agreements are complied with, this process will not start. Problems start once you are in default. So you want me to explain about the rights conferred on the borrowers in such a scenario. Now borrowers, what happens more often than not, they don't reply to letter of demand. They don't reply to show cause notices. Then bank adopt the resolutions, bank is, as per the section 8 of the Act number 4 of 1990, is obliged to send them the notices of the resolutions. So thereafter then they publish the auction notices under the section 9 of the same act. Then the auction is conducted. At that stage, of course, that is where we find borrowers are rushing to the court trying to safeguard their rights. Basically, their right to recourse to the courts have been well preserved by the courts. Our court, I can refer to a judgment, this Amaradas Aliyanage versus Sampath Bank, delivered by Her Ladyship Justice Shirani Tilakavarthana. Her Ladyship has held that this ambit and purview of this Parate execution to strike a balance between the rights of both the parties, while allowing the bank to recover their money quickly and expeditious manner to safeguard the interest of the customer also. So keeping in that mind, our courts have always, of course, more open than not, they have entertained the actions filed by the borrowers.
Exactly. Unfortunately, I'll have to cut in the middle of this explanation, sir. We do have to go in for a short commercial break, but we definitely have a lot more to discuss when it comes to the protections awarded to borrowers under Parate executions and how it's not just a one-sided law that will prey on vulnerable entities, and it's quite fair and just in most cases. But before we get into more specifics on how borrowers are protected, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Tehasa Setlini and I'm a student in grade 12. My question is on the current context. How have recent changes to Parate law reflected on the economy?
Welcome back to Law, Land and Liberty. We're in discussion with Mr. Priyantha Alagiyawanna, attorney at law, and we were talking about Parate law. Parate law, we just got into the very basics and the fundamentals and its intention of application in Sri Lanka as well. And unfortunately, sir, I had to cut you off in the middle of your explanation of, I feel like what the viewers would actually really want to know most about, and that's on the protections that borrowers are awarded. And as we just discussed in the previous segment, it's not a one-sided piece of legislature, a law, not piece of legislature. But if we could have a little bit more explanation and continue on what other protections are awarded to borrowers.
Yeah. So basically that answer is interconnected as to how our law has evolved in this regard. So when the Act was enacted in 1990, so there was no restriction regarding the third-party mortgage. The discussion was there up until 2005. The banks were allowed to sell the property mortgaged by the person other than the borrower also. So in 2005, there was a judgment, HNB versus Ramachandran case. There, the Supreme Court held that Parate execution is not possible for a third-party properties mortgaged by a person other than the borrower. Thereafter again, distinction was made in the Alagiyawanna case in 2007 when it comes to the property mortgaged by a companies. But other companies are virtually owned by the directors, and where the company and the directors had the benefit of the facility. So in 2011, again, by giving a concessions, one might say is a concession, the legislature enacted Act number 1 of 2011. By that, they introduced a threshold limit for Parate execution. Thereafter, the facilities in the capital amount was less than 5 million, bankers are no longer permitted to go for a Parate execution. And recently, by enacting Act number 24 of 2024, the government decided to suspend the Parate execution process, adopting a new resolution till 15th of December of this year. So, the rights of the borrowers are concerned, what happened usually in citing those loophole, whatever they are in the act, and the implementation process. You will see under the Act number 4 of 1990, the resolution must be communicated. So auction notices properly fixed and auction dates, place and time must be communicated. And there may be, you know, when it comes to the Parate execution, the board of directors of the bank sit as judges and then they themselves decide to sell the property. Then there are certain errors probably in the statement of accounts, the amount due. Those things are being challenged by the customers going to the district court, commercial high court and the court of appeal by filing an actions and application. I can elaborate more on that. They can go to the district court, file a plaint and challenge that if the value is less than 50 million in the present scenario. They also can go to commercial high court for high-end matters, value is more than 50 million. Challenge the resolution of the auction procedure, safeguard their rights. And of course, there is a tendency now to go to court of appeal and challenge by way of writ jurisdiction the action taken by the banks. Those are the avenue available to customers to safeguard their rights mainly, apart from making representation to the financial ombudsman and also the central bank, which also customers tend to use. And so this court has been inundated with application when this process, in operation prior to this enactment of Act number 24 of 2024, there are a lot of cases.
Exactly.
And those are still pending. It takes time.
Right.
And the court is called upon to decide on the validity of the resolutions.
Exactly. And also, as you mentioned, sir, Act number 24 of 24, it's very important for us to understand exactly how that reflects on the current context when it comes to Parate executions in Sri Lanka as well. Does this reflect negatively on the continuance of this law, or is it just because of the fact that it's still December, we won't see much of future implications? How exactly does that play out in our current context, sir?
So, you know, this act was enacted at the time it was introduced. Even prior to that, giving power to abdicating power of the court was looked at very disfavorably, and legal fraternity did not like it, whereas the bankers were insistent on that. So even in 2003, there is a special determination by the Supreme Court, then Chief Justice Sarathen Silva. He has clearly indicated now this has become the law. Now we can't change it. It has become the law, we can change it, but we can only interpret. So in that context, so law is there, but in the present scenario with the onset of this COVID-19 pandemic and other economic issues country faced over the last few years, there have been many demands by the business community, small scale businessmen, that this process must be at least temporarily stopped. I think in order to facilitate that only, this law was introduced. So under this law, what has happened really, adopting a resolution have been stayed, but resolutions already concluded by conducting the auctions, and there are many actions pending in the court, even District Court of Colombo, ejectment matters are pending. And of course, that's a sentiment, you know, from time to time, the legislature support to look at the interest of the masses. They have to take certain measures, but central banks clearly indicated, Honorable Governor has indicated that this system of Parate execution must be there to enable the bank to recover their money. So we'll wait and see what will happen after the 15th of December.
Exactly. We'll have to wait and see, of course. But a question of curiosity, sir, now, Parate executions, do you consider this in the financial field under, what banks would take as a remedy is a last resort, or is it something that institutions immediately turn to, in your experience?
Yeah, I mean, basically, I would like it is a last resort, in my view. So banks, there are certain classification when it comes to the bank's recovery process or the credit ratings. There are classifications. They allow some leverage, some time, and so then you send a letter of demand if there is no response, and then you send a show cause notices. So in order to send a letter of demand, show cause notices also take 2 or 3 months time. Then adopting of resolution take another time and another 1 or 2 months time, and then you have to publish it in the government gazette. Then the auction notices also publish. Entire process take some time, and then once the process is completed, since the borrowers are occupied in the property, then again you have to go to courts and obtain the delivery of possessions. So in order to avoid all this scenario, of course bankers, I believe, they prefer to give them the time and allow some leverage, and as a last resort, if it is not done, they will go for a Parate execution. But only issue is, it is not mandated that no time period is set up. Now under the Law of Property Act of England, once the default is done, in order to go to next step, there are certain time periods. Here our law has not set out such a time period. But since the statutory power has been given to the board of directors of the bank to implement, the natural justice require that they must be heard, given opportunity. So there is no uniformity to that also. In my practical experience, I say some of the banks, of course, they give a show cause notices. Some of them, they don't. And there is no uniformity. Those are the matters which must be considered by the legal fraternity, so that strike a right balance between two competing interests of the borrowers and the lenders. So you will see under the present scenario, lenders are desperate to recover their money. So borrowers are desperate to take more and more time and more time. So taking more and more time means you have to pay more also. That's why Supreme Court way back in 1990 in a special determination held that the recovery of money in a quick manner, expeditious manner, is the best interest of the borrower as well. So you pay your liability quickly. You wait more years, you have to pay more.
Wait for the interest to rack up.
Yes.
Exactly. In hindsight, and also when it comes to just, the basic understanding of it is the faster it is executed, the better it is on both sides. But there's also an issue, sir, of whether the rights of borrowers are appropriately protected, which we just tackled and we actually had a conversation about. But when you mentioned relating to the process that needs some reforms as well, there's no uniformity, as you mentioned. Along that line, what are some of the key challenges that you have seen faced by maybe the borrowers or the financial institutions when it comes to the implementation of Parate executions?
Yeah, key challenges as far as the borrowers are concerned, the reluctance in the part of the banks probably to give them the fair hearing before they resort to Parate executions. Because so once the borrower is in default, under the regulation enacted by the central bank also, the banks are obliged to take steps to recover its money. So they have only few remedies, and when it comes to the viable remedies, Parate execution rank very high. So they will be, naturally they will prefer to go for a Parate executions. So when it comes to the borrowers, of course, by the act itself, how their rights have been protected is set out in a different forms. You say resolution must be communicated to them. Auction notices must be communicated to them. So you can't go for a facilities, you can't go for a Parate execution for facilities less than 5 million. Those are the few safeguards given. However, the court has developed the jurisprudence, as I stated earlier in this judgment of Amaradasa Liyanage. Court is looking at the aspect as to whether the customer has been treated fairly, while ensuring that bankers will recover their money. That's a balance. Let the bank recover their money, but give them the opportunity. Give them the opportunity to repay. Intervention of the court is very vital because you see the legislature has given extensive power. No one can deny that. That is only given to the banks, not to other institutions. And they also probably wishing to have power like this. But the difficulty arising, once you go to court, you obtain an enjoining order. Sometime it is from time to time is extended. So then thereafter you can go on appeal. Appeal also at time take a time. After all these things, after 2-3 years, you sell the property. Then the borrower is occupied in the property. Then you have to go to district court to obtain a delivery of possession. So if there are no court cases, if there is no resistance, process is very quick. If there is a resistance, process is slow. And it probably may not be a draconian as one might claim. If someone wants to deliberately delay it, I have seen many occasions people are deliberately delaying this process because that's your right, entitlement. Now what I say, once the resolution is adopted, and yes, borrower must be allowed to challenge it if it is wrong, to safeguard their rights. However, once the property is acquired by the bank, it must be quickly disposed. So that is for the best interest of the lender as well as the borrower.
Exactly. We do have to get into the specifics on the role that the central bank plays when it comes to Parate executions and also alternative dispute resolutions that can actually negate the need for a Parate execution in the first place. But we have run to time in this segment. We will catch up with that in the next segment. Before we get into the specifics on the central bank's role and also ADR when it comes to Parate executions, let's take a short commercial break. You're watching Law, Land and Liberty. We'll be right back.
And I am a student studying in grade 10. My question today is on the future. Will we see drastic changes to the existing laws on parades?
Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Mr. Priyantha, Alagiyawanna, attorney at law. We were talking about Parate law, and I believe we covered a lot of ground when it comes to the fundamentals and also the current context and the balance that needs to be struck when it comes to Parate executions. So I think we do have to touch a little bit, even though we're running out of time, about the role the central bank would play when it comes to Parate executions, you know, being one of the key financial institutions in the country. Could you please explain to us briefly, sir?
Central bank generally supervises the conduct of the banks. However, when it comes to the Parate execution power, that is given to the banks by the parliament, by an act of parliament. So the board of directors are empowered to conduct the Parate execution. However, when it comes to the complaint by the customers, of course, central bank look into those complaints and make suitable directions. But central bank itself has no power to stay the Parate execution. That's a process given to the bank by an act of parliament. However, when they dispose in the property, etc., once the Parate execution is completed, when they dispose in the property, bank get the permissions of the central bank to sell it for a lesser price. And role is very minimum. However, of course, they are involved to safeguard the right of the customers. A complaint can be made to the central bank, then they will look into that. Quite apart from that, their not playing a major role.
Not a very intrinsic role, not very
Yes.
hands-on, but when necessary they will step in to regulate.
Yes.
Of course, as a regulatory body, that is what is expected of it. I think we have to talk about what we could do apart from Parate executions in itself. Alternate dispute resolutions when it comes to Parate executions. Does it exist, sir? Any sort of alternatives for Parate executions? Any sort of middle ground that can be reached beyond this piece of legislature?
Vis-a-vis the money lending transaction is concerned, ADR is possible. Alternative dispute resolution is very much possible. So, but the problem is here, property is involved. Under the process like arbitration, there is in order to enforce it, you have to go to the High Court. Here there is a mortgage property. Problem in our legal system, in order to enforce a mortgage decree or to sell the mortgage property, there is no mechanism. So court and the procedure is there when it comes to the disposal of the property by way of conducting the auction, bidding at the auction, then obtaining a delivery of possession. So that is why the ADR is not prevalent when it comes to the Parate executions. And of course, it's it is not possible because that process cannot be completed therein. You can, of course, as far as the loan transaction is concerned, you can resolve your dispute. But when it comes to enforcement, there is an issue.
Exactly. Alternate dispute resolution is not a standalone solution that can be involved because of the fact that there's such an entrenched object like property and mortgage property that's involved in such a dispute.
Interwoven.
Exactly. It's interwoven into the problem and therefore ADR itself would not suffice. Specifically speaking on that line as well, so when it comes to risk awareness, do you believe that borrowers would be adequately educated and aware on what risk factors exist when it comes to Parate executions and that awareness in general, has that been cultivated in Sri Lanka?
This law has been there for 30-40 years, 34 years exactly to be precise. So even every citizen is supposed to know the law. But there is a process, it's an obligation in the part of the bankers to inform the peril associated with the Parate execution. Because when you go to bank, you keep your property, you don't tell the customer in the event of your default, we will sell the property by way of Parate execution. It's happened naturally by following the process. If you are in default, if you have kept the property as a security, it will be sold. So I believe that most of the people, judging by the number of cases filed in these courts, the commercial courts and the court appeal, of course people are aware that peril and the issues associated with the Parate execution. But you decide to take a risk and pledge your property and take a facility. If you are in default, it is understood that of course property will be sold. If you have borrowed money in excess of 5 million. In this scenario, I think people more or less, by judging by the general thing, I don't think any survey has been done, but they know.
But through the influx of litigation in the courts as well, it's safe to assume that a lot of individuals are at least basically aware of what Parate executions entail and what rights are awarded to borrowers and lenders respectively. Finally, sir, we are running to time on this segment as well. I'd like to ask you about the future of Parate law in Sri Lanka. Do you think we'll see any necessary reforms in recent years, or will we see a development of Parate law and an inclusion, or would it be through Act number 24 of 24, was it the beginning of the downfall of Parate law?
So Parate execution law will stay in my view, because otherwise if this law is scrapped or it is abolished, there will be no opportunity for the bankers to recover their money. With the recent judgment of Sunpack versus DFCC, SCA Appeal 11 of 2021, the Supreme Court decided that even property borrowed by a mortgage by a person other than the borrower can be sold by a Parate execution. that may be one of the root cause or reason for this enactment of Act number 24, 2024.
Exactly.
However, this law, because what is important is strike a right balance. So borrowers have interest, lenders have interest.
It is not something that could be completely dismissed because it is able to navigate in between the proper interests, the conflicting interests of the two parties, and actually strike a balance without having to go through an arduous court process.
Yeah, it's a matter for the legislature to intervene and set up the law and probably made some regulations as to how process can be going, as to how more equitable remedies can be given to the borrowers before resorting to Parate execution.
Exactly.
And process has to be there to hear their grievance also.
Exactly. So, in conclusion, Parate law, execution law is not something that we'll see disappearing anytime soon because of the sheer potential that this piece of legislature has in order to strike a proper balance and also provide swift justice for lenders and also borrowers with added protections as well. Well, unfortunately, sir, we have come to time in this discussion. Thank you very much for taking the time to enlighten our viewers on exactly how Parate executions work and how it's not just something that has to be feared but rather navigated adequately in order to provide a proper balance and in the end justice for both parties.
Thank you very much for inviting.
All right, well, the proceedings surrounding Parate execution may seem convoluted, and therefore it's essential that those affected by such non-court related actions remain knowledgeable about its modifications and pitfalls in order to effectively navigate issues relating to foreclosure. We leave you tonight with the words of Brother Azarius, an Irish-American educator, essayist, literature and philosopher. Laws are not invented, they grow out of circumstances. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a great night.